an application and appeal in the matter of industrial cleaning equipment, Southampton Limited, and intelligent cleaning equipment, Holdings Co. Part Head.
Lady.
Yes.
I'm going to set about dealing with the remainder of issue 1 and issues 2, 3 and 6
Yes.
within the hour. I had got to the point of departure from Budvar.
Yes.
In order to deal with that, I should show you Budvar very briefly. Yes. Starting off in the Court of Appeal, Bundle A1.1, Tab 3. This is the reference to the Court of Justice. And the point here is that it's clearly established that the question of knowledge, the registration just wasn't an issue in Budvar. You can see that from the head note at page 43. Head note 3, the respondent applied to register its trademark on the 11th of December 1979. The appellant made a cross-application to register Budweiser on the 28th of June 1989. This was opposed by the respondent in 2000. The Court of Appeal dismissed both oppositions. On the 19th of May 2000, both appellants and the respondents were registered as owners of the respective trademarks of Budweiser. So they both knew about it then. And then this issue arose because on the 18th of May 2005, the respondent applied to the registry for a declaration that the appellant's Budweiser trademark was invalid by reason of its earlier Budweiser trademark, and it was done in the timing so that the 5 years wouldn't have passed for them, but would have passed for the other party. Just in passing, to make good a point that I made yesterday, and also to make good the point that acquiescence in the end wasn't the deciding factor in the Court of Justice. Paragraphs 51 through to 53 on pages 52 over to 53. Could I just ask you to read those, and you'll note at the end you come to the point that Lord Justice Jacob makes about legal certainty, and so where there's been long-standing honest concurrent use, each party has a valuable goodwill in the shared reputation, a goodwill which the law will protect against third-party usurpers. Now, if the law of trademarks is as contended for by AB, then one party will or may be in a position to destroy the goodwill of the other, nay more than that, effectively take it over. That hardly sounds right. Same kind of policy problem that acquiescence under the statutory regime deals with.
51 to 50.
53.
Yes, he was just reading from the end
I
of
was reading
53.
Yes.
Okay.
Yes, thank you.
Then the report of Budvar itself in the Court of Justice is taken from the 2012 report of patent cases 11, and the reason for that is, as well as having the full head note at paragraphs pages 62 of the bundle. This is at bundle A1.1 tab 4. We also have the Advocate General's opinion,
Yes.
which starts at page 69. And as I've set out in my skeleton, I'm not going to ask you to read it now, from paragraphs 34 through to 39, you have the arguments that she was addressing on question 2, when does the 5-year period commence? And you'll notice in none of those is the question of knowledge of the registration addressed. Then on page 86 of the bundle, from paragraph 75 onwards, the Advocate General addresses the question of knowledge, and as I've summarised in paragraph 36 of my skeleton argument, at sub-numbers 1 to 4, is, she explains that in paragraph 76, explains that limitation as a result of acquiescence has recourse to a subjective element, namely the trademark proprietor must have remained inactive for a period of time with knowledge of the fact that the other person is performing infringing actions. Accordingly, it should be required that the date of knowledge and the start of the acquiescence period coincide. Then in paragraph 80, the proprietor of the later mark's expectation that after 5 years from registration of his mark, no such application will be made for a declaration of invalidity also appears worthy of protection, as it may reasonably be supposed that the proprietor of the earlier mark must necessarily, in the course of that period, of that length, have been aware of the use of the identical mark, and yet took no action. Then in paragraphs 80 to 82, there was a debate about whether there should be presumptive knowledge or actual knowledge. But then, crucially, in paragraph 83, for the purpose of these proceedings, there was no need to reach a definitive conclusion on the approach to be adopted in relation to knowledge, since the question would probably only be relevant in a particular situation. In fact, one can think of lots of other circumstances where the different knowledge will matter. So the Advocate General didn't record any submissions or any reasoning in relation to knowledge of use. Yet, when we get to paragraph 87, the conclusions, he sets out bullet points of probanda to be applied. And the first one, bullet point, says 5-year period of acquiescence of the directive starts running from the time which the proprietor of the earlier mark becomes aware of the registration and use of the later mark. So that language just appears from nowhere without any reason.
Well, she says at 74 that it comes from the wording of Article 9.1. Does she not?
She does, but that's a jump from the language, where the language just says such use. My lord. So the kind of analysis that went on in Ghibli about the purpose of the legislation and that same analysis about purpose in high tech and so on, that doesn't give any reasoning, and she's already said that the point is not relevant, necessary to be decided for this case. Does that answer your lordship's question?
Yes, I was just suggesting that she does give a reason. She finds it in the language. Your submission is it's not backed up by any analysis of the purpose or the like, and the language is in fact ambiguous.
Yes.
But I think your submission is actually the language is the other way.
Yeah, my submission is the language is clear the other way.
I see, yes.
A number of people seek to find ambiguity. The judge at first instance in this case did by saying that that my submission as to what the language says on its face is perverse.
Yeah. So you say the language is clear,
yeah,
and that's supported by the policy reasons that you've prayed in it.
Yes. And what's more, if it had been an issue and there had been argument on the point, Ghibli and the reasoning in it would have been drawn to the attention of the Court of Justice.
Well, not necessarily. I mean, certainly you wouldn't necessarily expect that either the parties or the member states to do that. The Commission might, but of course, the Commission, although it does a fine job in the legal service, their resources are stretched, and scanning all the case law of the boards of appeal, I don't think one can be 100% confident. Is all I'm saying.
But the point I still make is that it is significantly after. This all happened significantly after the Ghibli decision.
Oh, sure. Yeah, I mean, one would hope that it would have been cited, but I don't think you could guarantee it. So does that take us to the Court of Judgment?
And then what happens in the Advocate General's opinion is that that point. If you look at the conclusions at 126. The advice is not at that level of granularity to the court. And then when one comes to the judgment that starts on page 100, what happens is that at paragraphs 53 to 58, my Lord Justice Nugee's point arises again, paragraph 53. It is apparent from the wording of Article 991 of the directive, 4 conditions must be satisfied, and the fourth one is the fourth prerequisite, aware of registration and of use. And that formulation of language is then repeated in paragraph 62 over the page 108. And then the same formula of language is repeated in paragraph 85.2. But there's no more substance in the reasoning than that. So, in the context of that, and of Ghibli, the clear meaning of the language, the policy in high tech.
Yeah,
and
well,
so
we've
on.
got all the reasons why you say that what's decided in Budvar apparently is wrong. But the question is, even if it's wrong, why should we depart from it?
And that's those are the submissions I turn to now.
Yeah.
So the approach is governed by section 64BA of the Withdrawal Act, and Court of Appeal is an appropriate tribunal under Regulation 3B, and Regulation 5 sets the test in deciding whether to depart from any retained EU case law. A relevant court must apply the same test as the Supreme Court would apply in deciding whether to depart from the case law of the Supreme Court. In my submission, that test is found both in the practice statement on a House of Lords judicial precedent.
Well, I don't think we need trouble with that. I mean, what we need to look at is the Supreme Court's own case law on when and how that practice statement should be applied.
I was going to add an and to that, though, that the case law applies as well. So in my submission, at least one aspect of the test that your lordships can take into account is the approach to not being bound by a proposition of law which isn't the subject of argument and isn't in dispute. But there are 2 ways in which that could be taken into account. That could be part of the test referred to in the regulation under the Withdrawal Act, or it could be a factor to take into account under the practice statement judicial precedent.
Well, I think in the present case, I mean, I understand you put it both ways, but realistically, we're looking more at the latter situation, are we not? Because whatever else you say about Budvar, the relevant proposition is part of the dispositif.
Yes.
So it's not merely, in Court of Justice prudence terms, reasoning along the way. It is actually part of the formal ruling. And we know that in the Court of Justice's own view, the formal ruling is the key part of the decision. So whatever its status might be, if we were viewing it from the point of view of domestic precedent, under its own system of law, that's significant.
I raised the possibility. I will address it on that basis.
Yeah.
So then the following principles can be identified, and I start off with the 3 principles that I raised or are raised in the case law that are said to be against me. Cases such as Budvar are retained EU law under section 6.7, meaning they continue to form part of domestic law and continue to bind lower courts. That's in tune-in at paragraph 74. The importance of certainty in the law is to be stressed. That's in paragraph 49 of Peninsula. It's never been thought enough to justify departing that a later generation of laws would have resolved an issue or formulated a principle differently from their predecessors. That's in paragraph 49 of Peninsula, citing Horton and Sadler. Nonetheless, fourth point, too rigid an adherence to precedent may lead to injustice in a particular case and also unduly restrict the proper development of the law. That's F to G in the practice statement. Fifth, whilst treating a former decision as normally binding, the court may depart from such a previous decision when it appears right to do so. That's in the practice direction at G. And then the principal development of the law can be a good reason for departing from the previous decision. That's Peninsula 50. And in my submission, in applying those principles to this case, there are nine or 10 reasons why departure is appropriate in this case. The first is that there is a clear inconsistency of the fourth prerequisite in Budvar and the policy and purpose of the statutory provisions in the recitals to the directive and in the case law such as Ghibli, the guidance in the EU IPO guidelines, High-Tech in the Court of Justice, Coombe in the Court of Appeal, and it's also inconsistent with the test applied in Ghibli and by the General Court in Turkava Yalari and EU IPO.
Why do you say it's inconsistent with Coombe, where this court repeated what had been said in Budvar?
So I said the policy and purpose of the statutory provisions analysed.
So you're relying upon what's said about the policy of these acquiescence provisions.
That's right. That's different from just quoting and saying it's not disputed, so I'm not going to address the actual provision.
Yes.
And what Coombe does is it adopts the approach in High-Tech, which is therefore binding insofar as it forms part of the ratio. So that's one reason I need to refer to it, but also expands on it in certain aspects. Then my second point is that the Imarci Italiani and Basile against Osra case that I took you through in the Board of Appeal, General Court and the Court of Justice shows how unsatisfactory the state of the case law is in the EU tribunals, and it would have led to a reference but for withdrawal from the EU. So in submission, that's a powerful reason for reconsidering and addressing the point, and if necessary departing, because otherwise the effect of the Withdrawal Act is the ossification of the English law when it could have been clarified by a reference. Thirdly, being constrained by the unreasoned formula in the fourth prerequisite in Budvar would unduly restrict the proper development of English law. That's the effect of such ossification. Fourth, the linguistic analysis provided, for instance, in Ghibli, in the light of the purposes set out in the recital, Coombe, High-Tech and Ghibli, addresses the three core things that I addressed yesterday and the additional one I added, striking the balance between the proprietor's interests and safeguarding its earlier rights in passing off against the interests of the other economic operators, such as the later trademark owner, in using signs to distinguish their goods and building up their goodwill in it. Secondly, limiting protection to those who are sufficiently vigilant. Thirdly, safeguarding legal certainty for users of registered trademarks who invest in them, coming second. And fourth, the public protection dimension. Fifth point is that Coombe establishes that the But what the proprietor of an earlier trademark or an earlier right does in relation to the registration of the later trademark, such as applying to invalidate it, is irrelevant to whether that proprietor of an earlier right acquiesces in its use. So logically, its knowledge of the state of the register must also be irrelevant to acquiescence. It doesn't fit into the scheme. Another way of putting the same point is, given invalidating the mark is irrelevant to acquiescence, why should the proprietor's knowledge of the registration be relevant in the light of purposes?
Well, that's an interesting point, but as you yourself pointed out yesterday, it's a single condition with two consequences. And I understand the argument that it's not relevant to the condition, and I also appreciate that this is all about when does time start running, and therefore we are concerned with the condition. But on the other hand, when you come to the consequences, one of the consequences is that you're prevented from applying for a declaration of invalidity. So how can one, at that stage of the analysis, say that the state of the register is irrelevant?
The underlying behaviour that the acquiescence defence is trying to control is the proprietor's behaviour in allowing what would be infringing marks to be used in the marketplace, so as both to undermine the distinctiveness of their marks and therefore their ability to reduce search costs for consumers. And that is what the knowledge condition is directed to. And it is therefore at the first stage of the single condition that the relevance of the such use.
Yeah. Well, and I suppose another answer is you can always do a search.
You can always do a search, and the register is available to you. It's available
That's what it's
for
there for.
transparency. And it comes on to my...
Sorry, I interrupted you.
I was going to say it comes on to some points I'm going to make later about the relationship with the register.
Yes. Can I just be sure I've understood? If someone is using an unregistered mark, you obviously don't have rights under the Act.
Yes.
But you have rights to stop it through the passing off.
Yeah.
Acquiescence, the 5 years only starts running once it's registered.
So limitation by acquiescence under the regime created by the directives and the regulation only comes into effect once you've got registration, because you become subject of that regulatory regime. Otherwise, you're subject to the law of the member state in relation to which the earlier right.
I understand.
So then we get common law acquiescence.
Yes, but it follows from that for statutory acquiescence, the inaction of the earlier mark proprietor for however many years up to the date of registration is irrelevant. So the 5 years can only start running after registration. So it's too wide a proposition to say for statutory acquiescence the state of the register is irrelevant. The state of the register.
Absolutely, you're absolutely right.
Yes.
That's not my submission. Knowledge of the state of the register is irrelevant. And one of the reasons is because the earlier proprietor's behaviour in relation to the register at the start date and to bring acquiescence to an end is irrelevant. Of course, the consequence, as my Lord Justice Arnold pointed out, does have a relationship with the register. I can't put that point too
Yes, but it's
high.
not just the consequence, but the time doesn't start running at all until there's registration.
That's correct. But that doesn't answer the question of whether time should start running only when the proprietor of the earlier right knows about the registration.
I can see that it doesn't answer that question, but it does mean that the submission, knowledge of the state of the register is irrelevant. There is at least a query over it, because unless the state of the register is such that the later mark has been registered, statutory acquiescence simply doesn't come into play. So it's not illogical to say you only know that your 5 years starts running once you know that there's been registration.
The provision doesn't say that. It says knowing of such use.
Yes, but the entire argument is what such is. Obviously, to know of such use, you have to know of use. What is the use you need to know of? And if the use you need to know of, this I think is the linguistic argument that underlies the Advocate General and the Court of Justice's decision in Budvar. If such use is use of a registered trademark, it's not difficult to say you don't know of that use until you know that there's a registered trademark that's being used. Hence, you must know that it's registered. That, I think, is the argument that was effectively accepted in Budvar.
Well, it's a reasoning that was
The
adopted.
reasoning, yes.
The argument wasn't accepted, and because no argument was made, the linguistic way of looking at such really stops holding water once you understand the purpose.
This is your
of the provision.
purpose and policy point.
Yeah.
Yes. Okay, I understand. Yes, thank you.
There's another question, which is, if you assume that it's use of the registered trademark, how far does that requirement of knowledge go? Does it require you to know the entire specification of goods and services of the registered trademark, the later one, which we know these days can easily be 9,000, 10,000 words? Does it require you to know whether the services in relation to which, or the goods in relation to which there is actual use, fall within the specification or a proper construction? Does it require you to know if the form of the use varies slightly from the mark as registered, whether it affects the distinctive character of the trademark? How far does it go?
All of those questions become much, much more acute if knowledge of the registration is required. Those questions are different if it's knowledge of the use. Because you know of certain uses, and the acquiescence defence, the time starts ticking. And then the question as to whether the statutory defence applies once time has ended is a question for the tribunal, applying that in light of the registration and its ability to construe it and so on. So your Lordship's point is a good point. In my submission, it's in my favour. Moving
On to your number 6, I think.
on to my number 6. In our submission, knowledge of the registration word being a relevant part of being aware of such use, it provides a perverse incentive for proprietors of earlier rights to close their eyes to the state of the registrar, and that's contrary to the purpose of the public register, which is to provide transparency. It just doesn't balance in the scheme. Or it provides an incentive only to gain such knowledge through privileged routes. That's talking about legal professional privilege, but it extends also to trademark attorney's privilege and patent attorney's privilege in relation to trademarks. My 7th point is proof of knowledge of use of a trademark on the market is straightforward because it's inherently susceptible to proof. Parties in the market are aware of their competitors, firstly. Secondly, they see each other's advertising and products. Thirdly, they compete for customers. Fourth, they come across each other at events such as trade shows. Fifth, in some cases, such as Ghibli and this case, they trade with each On the other hand, knowledge of the register is inherently less susceptible to proof. It's often mediated by professional advisors, such as trademark attorneys, patent attorneys or solicitors. And for instance, in relation to the trademark attorneys, Section 87 of the Trademarks Act provides that communications as to the matter relating to the protection of any design or trademark, or as to the matter any matter involving passing off, and B, documents, materials, or information relating to any such matter mentioned in that subparagraph are privileged. And there are similar provisions, statutory provisions, in the Copyright Designs and Patents Act 1988, section 280. Therefore, there's practical injustice caused by the requirement of proof of the proprietor's knowledge of the trademark, because it's inherently uncertain and difficult to prove. The second user, when they're trying to work out what their rights are, can't tell what they know. So that's the making decisions in business. And then when it comes to court, there's a massive uncertainty as to what they can prove, because they can only allege things by inference to start with, and then you get the kind of circumstance that occurs in this case. If you turn to Bundle 2, tab 14, this is a disclosure that we get on something that appeared to be a key date on documents from the just before the claimants applied for their registered trademark. They have D. Young & Co. carry out an IP audit, and there are emails between Darren Marston and Julie Kitchener, somebody also at ICE, and you can see page 63, 64, redacted, and an email referring to indicated during our brief chat yesterday, I'm still trying to wrestle with this subject. I wonder, has the ICE logo been registered as a trademark? Then on page, at tab 14.2, page 67, there's some exchanges about talking to people about it. And you can see that there's a DY active code about the IP audit at 67, but when you come to the subject matter, what are your thoughts on this? Over the page, again, redacted, and over the page, redacted again. And then on page 70, on the 13th of August, please proceed and instruct D. Young & Co. as discussed this morning. Also attached a copy of it.
But where does this take us? Because as I understand it, the evidence was, and the judge accepted this, that maybe for financial reasons, D. Young were instructed simply to file. They weren't instructed, as one might have anticipated, to search first and then file.
My point is that this is the practical example of the point that I was making, nothing more than that. Yes? That insofar as this IP audit had factual material in it that might have gone to that question of knowledge, no litigant would ever get access to it because it will always be privileged.
Yeah. Okay.
And then my 8th point is the fact that were this point the subject of English authority in the way that it's been dealt with at the Court of Justice, this point would have been no part of the ratio because it wasn't subject of argument in the sense set out in Bilter and tradition, and that is also a strong reason in support of departure. So I combined a couple of the points, and that's why I end up at 8. Moving on to issue 2, which is the date of registration. What we need to do is we need to look at the Madrid Protocol, the EU Trademark Regulation 2009, the EU Trademark Regulation 2017, being scheduled
that
to
yesterday.
be.
You showed us the relevant provisions in the 2017 one yesterday.
Exactly. So what I do need to start at the Madrid Protocol,
Yes.
which is at bundle A 2.1, tab 22. Starts at page 35. First relevant article is Article 2. Where an application for registration of a mark has been filed with the office of the contracting party, or where the mark has been registered in the register of the office of a contracting party, the person whose name, etc., may secure protection by obtaining registration in the register of the International Bureau of the World Intellectual Property Organisation. The key words of that: this is a case where there had been registration in the register of a contracting party, as I showed you when we looked at them. Then there's a nationality, domicile, or establishment requirement in Roman 1. And then we move on to Article 3.1. Every international application shall be presented on the form prescribed by the regulations. The Office of Origin shall certify that the particulars appearing in the initial application correspond to the particulars appearing in the basic application or basic registration. And there were some other things that are going to be indicated. So that's importing of the detail. 2 deals with goods and services. 3 deals with colour. And then 4, key thing, International Bureau shall register immediately the marks filed in accordance with Article 2. And the international registration shall bear the date of the international application when it was received in a particular time period, or otherwise when it's received. Then Article 3 bis. The protection resulting from the international registration shall extend to any contracting party only at the request of the person who files. And then any request for extension of the protection, this is 3 ter 1, any request for extension of protection resulting from the international registration to any contracting party shall be specifically mentioned in the international application. And here we noted there was a designation of EM, the EU mark. And then, crucially, Article 4.1a, from the date of registration or recordal effected in accordance with the provisions of Article 3 and 3 ter, the protection of the mark in each contracting parties concerned shall be the same as if the mark had been deposited directly with the office of the contracting party. If no refusal has been notified to the International Bureau in accordance with Articles 5.1 and 2, or if refusal notified has been withdrawn, the protection of the mark concerned shall, as from said date, be the same as if the mark had been registered by the office of the contracting party. And then Article 5 on page 43, where the applicable registration so authorises, any office of a contracting party which has been notified by the International Bureau of the extension of the contracting party under Article 3 TER, protection resulting from the international registration shall have the right to declare in a notification of refusal. So there's a possibility of refusal. There's a possibility of opposition. But then if you turn over to Article 5.5, any office which has not notified with respect to a given international registration any provision or final refusal in accordance with paragraphs 1 or 2 shall, with respect to the international registration, lose the benefit of the right so provided. So protection is from the date of registration under Article 4.1a, and then that is reflected in the regulations. And if you turn to bundle A 2.2, tab 28, page 374, effective international registrations designating the Union. So this is the EU trademarks before IP completion day. 1. An international registration designating the Union shall, from the date of its registration pursuant to Article 3.4 of the Madrid Protocol, or from the date of a subsequent designation of the Union pursuant to Article 3.2 of the Madrid Protocol, have the same effect as an application for an EU trademark. 2. If no refusal has been notified in accordance with Article 5.1 and 5.2 of the Madrid Protocol, or if any such refusal has been withdrawn, the international registration of a mark designating the Union shall, from the date referred to in paragraph 1, have the same effect as the registration of a mark as an EU trademark. So that applies the filing date at the International Bureau to the registration date. Shall have the same effect as the registration of an EU trademark from the date referred to. And that is also the same effect as Schedule 2B of the Act as it applies now. And we find that in Bundle A2.1 at tab 19. It starts on page 16, which is section 54A. Which says, Schedule 2B makes provision for international trademarks protected in the European Union, including certain expired marks, to be treated as registered marks with effect from IP completion day. And then Schedule 2B on page 19, paragraph 1.1, trademark which immediately before IP completion day is an international trademark which is protected in the European Union in accordance with Article 1892 that we just looked at of the European Union Trademark Regulation, is to be treated on or after IP completion day as if the application had been made and the trademark had been registered under this Act in respect of the same goods and services in respect of the international trademark is protected in the European Union. Over the page, a registered trademark, for registered trademark which comes into being by virtue of subparagraph 1 is referred to in this Act as a comparable trademark. 5. This Act applies to comparable trademarks IR as it applies to other registered trademarks except as otherwise provided in this schedule. And then Article 6.1a, comparable trademark is deemed for the purposes of the Act to be registered as of A, where the protection of the European Union of the existing IR-EU, from which a comparable trademark derives, resulted from a request for territorial extension article under Article 3.1, request mentioned in the original application, the date of registration of the existing IR-EU accorded pursuant to Article 3.4, and that's Article 3.4 of the Madrid Protocol, and we get that from the interpretation provision in paragraph 34 of Schedule B, which is from pages 22 to 23. Paragraph 34 2a, article after articles in the Madrid Protocol. So that's the point on date.
Can I be sure I've understood that? In 2015, the applications made to the WIPO,
Yes.
we know that since ultimately there was no objection, it's the comparable trademark now is deemed under Schedule 2B to have been registered as from that date. That's the 2015 date.
That's the conceptual point. The language, though, is that when the international registration is recorded designating the EU, and then there is no refusal,
Yes.
which is what gives rise to the right, the continuing right to be registered, then the Act implements that by this deeming provision.
Yes. But if you asked a question on January the 1st, 2016, say, is there a registered EU trademark? The answer is, well, we're still within the period where we're waiting to see if there's an objection. So we don't now yet know if this will turn out to be a registered EU trademark. Isn't that true?
Published on the WIPO database and available to everyone is a registration of an international trademark, which is still within the period where it could be the subject of refusal. That's not the same thing.
I see. You say that once it's published in 2015 under WIPO, it is, well, is it a registered EU trademark at that point?
It's treated
as an
by the EU as an application.
Treated as an application
in the EU, but it's an international registration, which then becomes deemed to be registered because the Madrid Protocol requires it.
And you go further. So you say that conceptually, the scheme under the Madrid Protocol is that once you have international registration, that gives you registration in the designated contracting states, unless and until a contracting state declares otherwise.
Indeed.
That's conceptually how you say it works at the Madrid Protocol level. And then you see what your next submission is that Article 189, paragraph 2 of the 2017 regulation, and indeed its predecessors, gives effect to that as a matter of EU law.
Yeah.
And if relevant, we continue to see the same effect under Schedule 2B. That's your case.
That's my case. Exactly. And we get assistance from that as well from Ghibli at paragraph 45, which is
okay, I haven't picked that up. Remind us where we find Ghibli.
A1.1, tab 1, on page 14. Secondly, it must be noted that pursuant to Article 6 CTMR, a community trademark is obtained by registration. This means that the rights of the CTM proprietor come to legal existence on the effective date of the registration of the community trademark and not upon a later date in which the registration will be published. Now, this isn't by reference to the Madrid Protocol, but it is consistent with what your lordship is saying.
It distinguishes between registration and publication, but how does that help us so far as the current scenario is concerned?
The Madrid Protocol provides the direct answer.
Okay.
Then,
sorry, if this was not an international trademark, so the Madrid Protocol had nothing to do with it, you apply for registration to the EU IPO, there's a gap between your application and when it's registered, but once it's registered, it dates back to the date of application. Does the 5 years for acquiescence start on the date that you apply, which is later when the registration takes effect from, or on the date when the processes have been completed and the registration is completed?
my submission, it would be from the deemed date of registration. In the case of a Madrid mark, it doesn't matter because there's a specific Madrid provision.
But I think, I mean, the argument is that it might matter because Articles 189 of the EU provision says with a Madrid mark, it's treated as if it were an application until the period for objection expires, at which point it's registered with effect from that date. So the question whether the 5-year acquiescence period starts from the deemed registration date, which is the date of application, in this case 2015, or the actual registration date, which in this case is 2016, is potentially significant, isn't it?
were one to go down that line of reasoning, there are very strong reasons to say that the deemed date of registration is the right one all the way through.
Right.
Everyone knows from the WIPO publication that there's mark in place. The proprietor of the later mark has put its rights in place, and if an earlier proprietor knows of the use, there is no reason in principle why the 5-year period shouldn't run from then, once they're part of the statutory regime, until 5 years after that. Because
Well, I take your point that the only certain point in an uncertain world is the filing date. But on the other hand, the counter-argument is, yes, that's the only certain date that everybody knows about and is publicly available. But what's the point if ultimately the application is going to be refused, e.g. on absolute grounds?
well, you don't get acquiescence if you get knocked out on relative grounds as well. If the mark's knocked out, you don't get an acquiescence defence.
Yep.
End of story. You're not entitled to the protection of the statutory regime. And that can happen for all sorts of reasons. Would now be a convenient moment to then move on to issue 3,
Yes, you've got.
which is whether the end of the 5-year limitation period occurred before the respondent alleges it stopped acquiescing. We say it only stopped acquiescing by serving the proceedings shortly after the 21st of September 2021, or perhaps under the Ghibli approach, when notice that a claim form had been issued was sent in the June before that, in June 2021. We say, firstly, the period started on the 18th of June, and therefore it had ended, so 18th of June 2015, and therefore it had ended on the 18th of June 2020. Secondly, if the period started when the international registrations were referred to as being accepted, i.e. there's been no refusal under the Madrid system, then those dates would be from the record of the registrations the 24th of May 2016 and the 14th of June 2016. As a result, in relation to the word mark, time would have expired at the end of the 5 years after that, on the 23rd of May 2010, before the claim form was issued on the 24th of May on the 23rd of May 2021, before the claim form was issued on the 24th of May 2021, and before the claim form was notified but not served on the 22nd of June 2021, and before the claim form was served on the 21st of September 2021.
Can I just check?
Yes.
If time starts running on the 24th of May,
Yeah.
2016, you say it expired on the 23rd of May,
Yes.
and that if issuing the claim form is the relevant act,
Yeah.
doing it on the 24th is one day too
Yeah.
late.
Yes.
Is that common ground?
No.
No. As a matter of the English law under the Limitation Act, I think that if you issue on the corresponding date, you are just one day in time. Is that the case, or have I misremembered that?
I haven't looked at it recently
Right.
either. There would be an argument about that.
I see. Okay.
And it may be that that intermediate point falls away, but if you've... Let me move on to
Yes.
the third scenario. That if the period started when no refusal is published, you don't understand the basis for going down that route, which is the 25th of May and the 15th of June 2016. The 5-year period had expired both before the claim form was notified on the 22nd of June and the claim form was served by the first past post so as to achieve service shortly after the 21st of May, so 21st of September 2021. That's our position. Now, in terms of why not the date of issue, the whole regime is about use on the market and opposing that use. So you end up with the argument in high tech that you might oppose the use and so not acquiesce by writing a letter and then taking steps to stop.
Yeah, but what high tech tells us is that when you're concerned with issue and subsequent service, the question is, have you done it in accordance with your domestic procedural law? And under our domestic procedural law, you're allowed 4 months to serve your claim for.
Indeed, but so far as that's the relationship between a claim form being valid, but so far as the not acquiescing actually having an effect on the later user, that can't happen until the later user knows about the issue of the claim form or it's actually served. So in my submission, high tech comes up with a formula in relation to that. Your Lordship's absolutely right. And that formula includes it doing something in accordance with the rules. But if you take the principle of high tech, which is persuasive authority, then the principled solution is when there is communication. And what is said is that a letter on the 2nd of July 2019, called the letter referred to as a letter before action, and then a subsequent letter on the 18th of December 2020, pleaded, and issuing the claim form on the 24th of May 2021 brought the period to an end. I can show you those letters quickly.
Yeah.
Bundle. And the way it works out is there are these dates that are relied upon, and there are interstitial events, which I'll just tell you about, and long gaps. So the first letter for action is Bundle 2, tab 16. It's a true letter before action, annexes, and so on. We act on behalf of Industrial Cleaning Equipment on page 74. It's sent to TL Killis Limited, which is the third defendant, not one of the liable parties. And it's notable that it's only said that acquiescence comes to an end in the pleading on the 26th of July, when the representatives of the first defendant respond. And there's a logic to that, the pleader, because they don't know when the first defendant became aware of this threat of litigation until it's responded to. And you can see at the end on page 76, this trademark infringement of passing off is unacceptable, requires signed undertakings by the 16th of July 2019. So if proceedings had been issued and served in August 2019, we wouldn't be here. But that's not what happened. What happened was on the 26th of July 2019, there is a full and careful response from Decisis Intellectual Property, and you can tell because they're regulated by IP Reg that they're trademark attorneys, explaining why section 10.1 doesn't apply, because there's no identity of registered signs, registered mark with registered sign, and no identity of the registered services for the goods being provided. There's also the point that services are being provided by Killis under the mark Killis. Then response in relation to section 10.2 saying no likelihood of confusion, and in relation to section 10.3, no substantiated unfair advantage or detriment and other things, each time also pointing out that at least 5 years prior to this matter, the goods have been on the market. The rejection of the claim of passing off, as well as a mention of section 11, and then the explanation of the counterclaim that I showed you before. Look what you're now doing, selling all these ICE products, which conflict with the ICE mark products that ICE China has been importing to the UK for at least 5 years. And then, crucially, the last sentence on page 4, in the circumstances our clients refuse to provide the undertakings required in your letter or any of them. So that is an absolute refusal. Then what happens, you can find in the chronology, bundle 1 at tab 6, so the letters are on page 93, 2nd of July and 26th of July. Then on the 12th of November, Mr. Bresnahan of the claimant and Mr. Schlesch of the second defendant meet to discuss a Whiz robotic product in a restaurant in King's Cross in London. So they meet to discuss collaboration, not dispute, and that's dealt with in paragraph 101 of the judgment. Then on the 20th of November 2019, Mr. Bresnahan and Mr. Marston met Mr. Schlesch and Mr. Chen of ICE Group. So Mr. Schlesch is of the second defendant, and Mr. Chen is of ICE Group, at a breakfast meeting at ISSA in Las Vegas, cleaning show. And there's detailed analysis of that meeting in the judgment, and it's clear that 2 subjects were discussed: the trademark, where the outcome was subsequently disputed in the evidence, but also inconclusive, and collaboration, where the outcome was positive. And then we can see that that outcome was positive so far as collaboration is concerned, because on the 14th of December 2019, Mr. Schlesch, the second defendant, sends an email to Mark Bresnahan, and that's at bundle 2, tab 18. And that email, so that's page 81. Can I ask you just to read the email?
You're on borrowed time.
I'm on borrowed time, absolutely.
Sorry, what is that reference again?
Bundle 2, tab 18.
Thank you.
Page 81. As you read that email, you'll see it refers to good talks, it aims to facilitate a business model, it provides general rules of engagement, entering into a professional network of collaborating companies. We play alongside each other, not against each other. We strive for service excellence, full service proposition. ICE Robotics UK is the connecting platform. All invoices will go to ICE Robotics UK. The network will have a clear regional segmental split. And it talks about quarterly meetings. So clear, the use of ICE is continuing, and the goal is collaboration. Then over the page on the 20th of December, so this is now a significant period of time after the original letter before action, some 5 months. There's an email from Mr. Marston who talks about, thank you for accommodating us at the breakfast meeting, talks about a pragmatic view of the trademark challenge which we face together. The invalidity action has been suspended because that was issued on the day of the first meeting. Keen and committed to work with the team. Mutually acceptable commercial solutions to be found. However, we must protect the ICE acronym in our space which includes robotics. Talks about SoftBank, who's the collaborator with ICE Group in relation to the Wiz product. We see the entity ICE Robotics being promoted as some kind of controlling body. To be clear, this is a problem for us, as previously identified. And then above that, there's a reference to your suggestion that the organisation uses the full name Intelligent in the UK. So I'm hopeful that we can move forward in that way. Mr. Schleff said that he didn't read that as indicating that they would stop using ICE, and that was a matter of dispute. And the judge came to the conclusion that the parties took away a different message each. But notice there's, so far as the acquiescence point is concerned, there was a letter before action and now a delay of 5 months during which trademark invalidity proceedings have been suspended. There's been discussion of collaboration, and there's a mention in this letter of concerns in relation to the trademark. Then again, there is nothing until the 18th of December at tab 21. So this is 12 months after the 19th of December 2019 email, where a letter is written to Dorsey and Whitney saying, thank you for confirming your new representatives. We note that the EU apparent records in relation to trademarks have not been amended. Talks about the groups of companies, and then we summarise our understanding. Our clients assert a prior right in relation to ICE in the UK.
I don't think we need it through. You really are pushing against the wire from a time point of view, so we can skim read this. I don't think it's necessary for you to
skim read it.
out.
What they say they've done is they've instructed counsel, your use won't be tolerated, and our client, they're considering their options, and the client's rights are expressly reserved. Now, 12 months since the email and the 5 months before that is not prompt action. Then what happens is that the invalidity proceedings are dropped 2 months after that, and 5 months after this letter, the claim form is issued, but there's no communication about it at all. It's only on the 22nd of June, which you find at tab 22, that a further letter before action is sent, which attaches the copy of the claim form with Annex 2 by way of information for the avoidance of doubt, not by way of service. So that's 9 months.
Yeah, well, we've got the chronology.
You've got the period. So we say that that's not prompt action, so that the only relevant effective communication is the one in June. Can't backdate it using the high-tech mechanism. And then all I need to do in relation to the 6th issue is point you to my submissions about consequences.
Yes.
In paragraph 11 of the grounds of appeal, which sets out in detail how those consequences knock on in relation to issues 2, 3, 5 and 6, which end up with reversal. That's trial issues 1, 2, 3, 5 and 6, as I showed you. And then in relation to issues 7 and 8, which are the counterclaim to invalidate the claimant's marks and the counterclaim for infringement, they can only be dealt with by way of remission, but can't possibly be just dismissed once this appeal has succeeded. And therefore, that's why we say that's the solution. I apologise for preying on your time. If you don't have any more questions.
It's not us you need to apologise.
I have already apologised to Mr. Campbell and told him that I
Any further
was
questions?
doing my best.
Well, we're very grateful. Any further questions? No, thank you very much indeed.
My lady, my lords.
Yes, Mr. Cameron.
My respectful submission, this appeal is really rather simple. As my learned friend indicates in his grounds of appeal, paragraph 3, I'm not going to go to that. The appeal raises two issues of law relating to the defence of statutory acquiescence arising under section 48 of the UK Act. And there are two, and only 2 points in the respondent's notice. Now, I'll deal with them at a high level. The first issue on the appeal is whether this court should depart from retained law of the Court of Justice in Budvar, in particular as regards the 4 prerequisites for the defence. And that departure requires my learned friend to satisfy my lady and my lords that the test under the European Withdrawal Act 2018 is satisfied, and I call that the Budvar point. And my submission is my learned friends come nowhere near passing that high standard. And if my lady and my lords agree, it follows the appeal must be dismissed, and we can all go home early without considering any of the other 3 points. The second issue is the relevant date for purpose of applying whatever the correct legal test is, assuming that my learned friend has persuaded this court to depart from the Budvar test. Now, is it because if the first point of appeal is dismissed, the date is 2019, as the judge said, it doesn't run. So the second issue is the date point. And the question is the correct date for purpose of whatever the test is, the date when the mark is actually registered in the sense of it's been an application, it's been examined, and it's entering onto the UK register, or the UIP register? Or is it the date of original application, as my learned friend says, prior to any examination at all?
Well, one's got to be careful about that. I mean, it's a point he skipped over, but since you've mentioned it, I'll mention it now, which is, of course, this all stems from an underlying basic application, which in the instant case was in the US.
Yes.
So you have a US application leading to a US registration. That's the basic registration, which then founds the international registration, which follows.
Yes.
So one always has to be a little bit careful about what one's talking about.
Well, absolutely. But the end result is that the Madrid Protocol Art 4 says it's to be treated as if it was an application under the UK Act. That's the end result we've now come to. But it's been a very circuitous route. I do have submissions on that, but my lord is right. There is that complexity. And I'm going to call that point the date point. Now, unless my learned friend wins on both the Budvar departure point and also the second point, the appeal must, in my submission, again be dismissed because the earlier mark was entered onto the UK register on 25th of May 2016. Now, that was one thing my learned friend didn't actually show the court, so I will do. It's supplemental bundle tab 12. And as my lady and my lords will notice, filing date of 18th of June 2015, but the date of entry in the register is 25th of May 2016, so that's the key point. And this is the current printout. And the claim form, of course, was issued on 24th of May 2021. My lady and my lords were taken to that as core 11 page 185, so that's a day less than 5 years. That's why we have that argument. And those were the 2 grounds on which my Lord Justice Arnold grants permission to appeal. Now, the consequences, if the appeal succeeds, are set out in my learned friend's grounds of appeal at section 3, and my Lords did look at that. Essentially, my learned friend invites this court to set aside the key portions of the judgment and order and also remit the case back to the Intellectual Property Enterprise Court, so that he can continue his counterclaim to invalidate my client's trademarks and sue my client for infringement of the first defendant's trademarks, the first defendant being the BVI company. Now, my learned friend sought to suggest yesterday that his client's counterclaim for infringement was limited to some sort of expansion of my client's activities. the relief he actually seeks on his counterclaim is an unqualified injunction to restrain any infringement of the first defendant's mark. I will show my lords that. It's CB tab 13, page 223. And if I want to have whole bundle, tab 13, page 223, paragraph 3 of the counterclaim is the general injunction restraining the claimant from infringing his 685 mark. And that's sought so as to prevent my clients using the trademark ICE in the UK for their goods and services. Now that's the nature of the appeal and the objective Millennium Friends seeks to accomplish. The issues in the respondent's notice are essentially two.
Well, can I just ask you this? I mean, I haven't read this through in any detail, but I noticed if one takes paragraph 29 of the counterclaim by way of example,
Yes.
the complaint is in relation to goods. There's no claim generated in paragraph 29 of infringement in relation to services, and that was what I understood the point Mr. St. Bill to be making, which is the complaint is about use of the allegedly infringing sign on goods, not on services.
Yes, the injunction is not so limited.
I don't understand that because it's to restrain the alleged infringement, and the only complaint is in relation to goods.
Well, if Millennium Friends is undertaking will never sue us for services, that would be one thing. But then...
He hasn't sued you for services, is my point.
Yes, no, I understand that. But the relief he seeks goes broader. That's the simple point.
Okay, thank you.
And clearly he's suing us for our core business. I made that point anyway. Now, so far as the respondent's notice is concerned, I've said there's 2 points. One relates to when any period of acquiescence ended. So Millennium Friends has to win on his first point anyway. And I'd submit he has to win on his second point as well. But what Millennium Friend then has to grapple with is on the respondent's notice we offer alternative dates for when the period of acquiescence ended. And Millennium Friend's been through these dates: first letter before action, second letter before action, and long stop of issue proceedings. Now that's a matter of trademark law, and I'll call that the end of acquiescence point. And again, if you win on that, then the appeal must be dismissed. And then finally, we say our passing off claim succeeds. Alternatively, should be remitted for determination because statutory acquiescence doesn't apply to passing off. And I'll call this the passing off point. And can I just be clear what I mean by statutory acquiescence? Passing off is a common law, non-statutory tort. Millennium Friend has no case of acquiescence under the normal domestic law, by which I mean things like equitable doctrines of laches, acquiescence, abandonment, and delay. It's not that. These would all, had they been pleaded in evidence and argued and so forth, they might conceivably be non-statutory defences to passing off. But he only relies on section 48 of the Act, hence the term statutory acquiescence. And the dispute there is whether the statute, that part of it, provides a new defence to passing off, given the terms of section 2.2 of the Act. Now, Millennium Friend did plead other arguments on passing off. He says there's no confusion and so forth. But the judge dealt with the substance of these when considering validity of Millennium Friend's 2015 and 2020 trademark registrations. And the point I would emphasise here is Millennium Friend's appeal fails. I don't need to pursue the respondent's notice as well, although clearly I'm going to address the court with submissions on it. Now that's the high level as to what the 4 points are. I'm going to address the court on some points of factual background. I appreciate the 2 points in the appeal are points of law. I appreciate the court has read the judgment below. I'm not going to spend very long on this, but I want to draw out a couple of points as follows. And these are the judge's findings of fact about the parties' presence in the UK market and their relationship with each other. if my lords go to the judgment, which my lords and my lady have separately, if the court goes to paragraph 54, I'm not going to read this out. I'm going to summarise paragraphs 54 to 56 to say that my clients were founded in 1967, been selling and renting commercial cleaning equipment in the UK under the brand name ICE ever since its inception. That's set out in 54. 55, very substantial figures for turnover, and 56, a summary of very extensive marketing. I don't need to read the next section, which deal with logos. There was a dispute at trial as to whether my client's business was local or national in UK terms. One of the defendant's witnesses, Mr. Killy, sought to dismiss her business as being merely local, but the judge dealt with that at the last sentence of paragraph 63, page 39 of the judgment. And Mr. Killy was director of the third defendant, managing director of the fourth defendant. And Mr. Killy accepted as oral evidence at least the last 5 to 10 years, claimed it's been one of the largest independent distributors in the UK, along with Killis. It was a major supplier with a turnover of over 9 million in 2010. So the key point here is my client's use of the ICE mark in relation to selling and renting commercial cleaning equipment is and was, prior to the defendant's entry into the UK market, both long-standing and extensive. I'm not going to go through the specific findings about my client's goodwill. My lords and my lady will have read that. The next section of the judgment is all about the ICE group. Now, essentially, as the judge found in paragraph 126, we don't need to go there, they entered the UK market on what was initially a small scale, and certainly much smaller than the claimant, in June 2014. Now, my learned friend has, in writing, to a lesser extent orally, he's made much of the fact that my client's evidence was they were unaware of defendant's use in 2014 until they corrected that statement before the trial. My learned friend explored that topic at trial, but the judge found both of the claimant's live witnesses, Mr. Marston and Mr. Bresnan, to be good witnesses, and Mr. Edwards' evidence was not challenged at all. And that's important because the judge accepted in paragraph 158 of the judgment, I accept Mr. Marston's evidence that they were not aware of D1's 2015 trademark registrations until 26 July 2019. And my learned friend spent a little time on that, but he didn't seek to appeal that finding of fact, even if it was open to do so. In fact, the judge criticises Mr. Pang's evidence for the ICE group in paragraphs 69 to 70. Now, why does this matter? It simply matters to reinforce the judge accept my client's evidence on the key point in the case. And the other part of it is the defendant at all material times knew about my clients, about their mark, and their position in the UK market, but they carried on regardless. And as the judge sets out, again, I won't read it out, there was only limited use by the defendant up to March 2019, but then there was this big show, the cleaning show held in the UK in March 2019. And my lady and my lords might be struck by some of Mr. Killy's evidence on behalf of the defendant at paragraph 94. The judge quotes that. This is Mr. Killy's evidence, and he's the director of D3 and the managing director of D4, talking about this launch of the defendant's machines. He says, however, seeing that some customers associated the ICE branding with products sold by the claimant under its own ICE brand and wishing to avoid any such association with the claimant's products, I was inclined to reduce the emphasis on the ICE branding of machines. Around April or May 2019, I asked Michael Pang if the ICE group could supply us with machines not displaying the ICE logo, and we see that 125 units. So the judge is struck by the evidence from the defendant's own witness talking about this confusion in the marketplace. And Mr. Killie reinforced that evidence as noted by the judge at para 152 of the judgment. I also note Mr. Killie in oral evidence accepted that a consumer only aware of one or other company, C or D1, would be confused if they were presented with a brand name or the logo of the other company because of the similarity in the branding. He said, well, of course, because the names are the same. There was even more evidence of confusion from a later period of time, as the judge noted at para 176 of the judgment, which was after another trade show, this time called Interclean Amsterdam Show. And the key points here are all this customer confusion with Mr. Killie himself observed, so concerned, and we asked the defendant to stop using its mark, which it did for 125 machines. Confusion arises, as Mr. Killie says, because the names are the same, and the confusion carried on. So why have I spent some time on this? Well, it's to reinforce the point that despite my client being the senior user, and despite all this confusion, the actual result of this appeal is to try and shut down my client's business in relation to the matters set out, particulars of claim. That is the factual background. Against that, I then come to issue 1. And the issue 1 can be framed in various ways, but the key point is, should this court depart from Budvar? Very striking, my learned friend spent the whole of yesterday afternoon addressing this topic, and he never got to the leading authority on this until we got to it today, because that's where I would wish to start. Or rather, that's the first authority I'll look at. The first point I would look at is to look at section 48 and the wording of it. Now, that's in multiple places in the bundles, but the judge set it out correctly. My lady and my lords have the judgment loose, then paragraph 30 is a good place to find it. And I'll say once, my learned friend went through multiple versions yesterday of all these directives and regulations. I don't think anything turns on that. The only change is some confusing renumbering. But in any event, I'm not going to read it out, because my lady and my lords have read it any number of times. But we say the key words here are, indeed, use of a registered trademark in the United Kingdom. I've underlined a registered trademark. And being aware of that use. And that's the triggering condition. And then we get on to A and B. Now, linguistically, it's specific to use of a registered trademark. It doesn't say, in the opening words of section 1, it doesn't just refer to a later trademark. Because in the rest, even though in the rest of this section, and also the next, it does use the word later. My submission is that the reason it uses the word use of a registered trademark is to emphasize the important thing: it is registered, not that it's later. And when it says being aware of that use, it doesn't say being aware of the use of the later trademark. And that if it had done, then that might have suggested the registration wasn't important. But when it says that use, it's clearly referring to use of a registered trademark. Now, my learned friend said quite a lot about policy, but and I will too in answer. But it's hardly a difficult burden for the trademark proprietor to inform the public that his or her mark is registered. Now, I'm not talking about the register being a public document, because clearly it is publicly accessible. But many proprietors will, for instance, apply the R in a circle logo, or they will tell the public on product packaging or literature that such and such is a registered trademark. It's not a difficult thing to do. In my submission, one of the main reasons for applying for a registration is precisely so you can tell people you have one. Anyway, I refer to this part of the section as the triggering condition, or Lord Justice Arnold rather call it the condition, we can call it the condition. The sections A and B are spelling out what the consequences of the condition is. Now, the same condition applies to both A and B. So, the wording must be given a meaning which applies consistently to both. And that's important because my learned friend, he repeatedly emphasises B. He spent far more time talking about B than about A until my Lord Justice Nugee reminded them of A. And my learned friend emphasises the reference to use, but we have very much less about the entitlement to apply for a declaration the later trademark is invalid. Now, if anything, A in my submission would be the more important because that's a mandatory provision of Article 9(1) of the Trademark Directive, which all member states were required to enact, whereas B comes from Article 9(2), which was optional. But I say it's the same condition for both. Now, what about point A? Point A assumes there is a registration of the later mark because it refers to a declaration of invalidity thereof. And it also assumes the proprietor of the earlier mark or other right has the right to apply for such a declaration because it refers to the entitlement ceasing. An entitlement cannot cease if it doesn't exist at all or not yet. Now, point B, it also covers the ground of the second point in the respondent's notice cross appeal, but ignore that for the moment. It refers to use of the later trademark in relation to the goods or services in relation which it's been sole use. And as with A, it assumes the earlier proprietor has a pre-existing right to oppose such use, meaning the use in relation to the goods or services question, since that entitlement also ceases when the condition is met. And then the final wording of this section, unless the registration of the later trademark was applied for in bad faith. Again, my submission, this shows the drafter thought the later mark had to be registered, since otherwise the wording of applying for it in bad faith doesn't make sense. There's no such thing as an application for an unregistered mark, so it can't be made in bad faith. So, my lady, my lords, once you realise that the section consistently assumes that the later mark has to be registered, you then go back to the wording about acquiesce in the use of a registered trademark in the United Kingdom, being aware of that use. I do submit the only realistic conclusion is you have to know the later mark is registered in order for the section to bite. Now, that was certainly the judge's view, as set out in paragraph 48 of the judgment. And it's also the view of the Court of Justice and that of the Advocate General in Budvar. Now, just exploring my learned friend's logic a little bit further.
Just before you go on, you said that it was easy for the proprietor of a registered mark to tell people that it was registered by putting an R in a circle,
yes,
which is something we're all familiar with. Does that have any particular statutory force, or is it just a custom?
Well, it's certainly a criminal offence to do so unless the mark's actually registered.
So the answer to the question is it's a practice that derives from US trademark law. And in US trademark law, notice of the registration is very important because the Lanham Act works in a different way to European legislation. And so it's quite important under US law. In English law, it has no significance at all that I'm aware of.
I'm very grateful.
Apart from what you say about it being a criminal offence to say that, where do we find? Don't show us, just tell
I've got
us
that somewhere else in my submissions, but it's somewhere about. I'll answer that question in due course if I can.
Thank you.
But in any event, moving on to another part of my learned
It sort
friends.
of ties in with the bad faith aspect of it as well, doesn't it?
Actually, no. Bad faith is the application for the later mark.
Right, of course.
Whereas if you falsely say your mark is registered when it's not, that's where the offence would lie.
Well, of course, you could falsely register a later mark.
I'm sorry, Lily?
You could falsely register a later mark. You know, anyone can register.
Yes, you could register one in bad faith, but then it'd be liable to be ruled for bad faith.
Yes.
Now, my learned friend, continuing with his logic, he accepts that for purposes of consequence B, the earlier proprietor has to be shown to know of the use in question. And I'm not sure he actually said it, but that must be on the grounds you can't acquiesce in something you know nothing about. And I would understand that logic. Now, consequence A is dealing with an application for a declaration of invalidity rather than opposing use. But why should this not require knowledge of the registered trademark in question, by analogy with the knowledge required under B? Put another way, why should it be so important to prove knowledge of the use for B, which deals with the use, but not to prove knowledge of the registration of A, which deals with the registration? What aspect of wording or policy drives the court to the conclusion that knowledge required should be so different? We say there's none. Now, I accept it is, of course, possible you might have a right about which you knew nothing. But, of course, you certainly can't know a mark is registered until it's actually registered. This is one of my Lord Justice Nugee's questions. 1st January 2016, the mark wasn't registered, so you couldn't know it was registered because it wasn't registered as of that date. But sticking with the point about you might have a right about which you knew nothing, why is it fair to proprietors for time to start running for the time in which they can exercise a right to invalidate the later registration, even though they don't even know they have such a right? Now, our Lord Justice Arnold said you could always do a search, but there's nothing in section 48 imposing an obligation to do that. You have to take people, in my submission, as you find them. Of course, the law applies to all earlier proprietors, great and small, and not everyone has a dedicated trademark watching service for earlier marks or can afford one. And if you didn't know the later mark was registered, you would have had no idea about your existing right to apply for a declaration that the registration of the later mark was invalid. Now, thus far, I've addressed, my lady and my lords, on the wording of section 48 itself, but as the judge noted, equivalents were found in successive European directives, and I've already referred to Article 9. I'm going to go to this one because it's got the recital in it, well, the important recital, at any rate. If I can invite the court to take A2.1. Tab 23. This is the first version of the Trademarks Directive. And the recital, well, our friend took the court to various recitals, including the one at the bottom of page 69. But in my submission, the important one is really the one towards the end of page 70, whereas it is important for reasons of legal certainty, that's the first point, and without inexorably prejudicing the interests of a proprietor of an earlier trademark, that's the second one. And then it goes on to say, to provide the latter may no longer request a declaration of invalidity, nor may he oppose the use of a trademark subsequent to his own of which he has knowingly tolerated for substantial length of time unless in bad faith, etc. Now that's not quite the same wording as Article 9, but it's not required to be. It's setting out the policy. And in my submission, there's only two elements of policy. The first one is legal certainty, and the second is about without inexorably prejudicing the interests of the proprietor of an earlier trademark. There's no other policies mentioned. In his oral submissions, my learned friend told my lady and my lords there were 6 policy considerations, although in the end I only counted 5. But one of his is described by my learned friend as public protection. But my learned friends seem to equate this with allowing infringers to carry on infringing. Unless public protection is just saying the same thing as legal certainty and without inexorably prejudicing and so forth, I don't see where it goes. In any event, these are the policy considerations. There are no others in my submission. Now, actually, while we've got that, I'll just remind my lords and my lady, I think I made the point anyway, but Article 9.1 being mandatory and 9.2 is optional, that's page 75. I don't think it's necessary to go there. Can I invite the court to consider Budvar? Now, before we go to it, can I make a number of points about it? And the short point is one I've already made. It's retained law, and this court should not depart from it. And if I need to go any further, I say it is also clear, simple, authoritative, binding, not undermined by any of high-tech, the Board of Appeal decision in Ghibli, Hava, or any of the three decisions in Basel, or by this court's decision in Coombe. On the contrary, Budvar remains the foundation of EU law on acquiescence. Now, part of my learned friend's submissions were to rely on UK doctrines of obiter dicta and per incuriam. I'm not sure he really pursued those orally. After my Lord Justice Arnold pointed out that, first of all, these doctrines don't apply in EU law anyway, and these paragraphs, the key paragraphs, are in the dispositif.
I think he relied on it as a factor.
Yes.
Which he said was a strong factor why we should depart from it. The fact that it doesn't seem to be the subject of argument or relevant to the issues in the case.
Yes, no, he does say that. And I'll demonstrate, well, it was the answer to the question they were asked. And one can't strip it out. I mean, that's actually the next point I was going to make. Can I just look at the questions which were referred to the court? And it's authorities A1, it referred to the Court of Justice. I don't think we need to look at the English Court of Appeal decision at all, really. The Court of Justice decisions A1.14, page 103. And at para 96, we see the questions which were actually referred. Now, the important ones for present purposes are 1A and 2. Because 1A was, is acquiesced a community law concept? Answer, yes, it was. We don't need to go to that, but it's, for instance, paragraphs 37 and 50 of the Court of Justice judgment. Now, the point of question 2 was to ask a number of questions about the period of time, but it concludes by saying, and if so, what conditions are necessary to set time running? Now, the English Court of Appeal, this court, it didn't purport to put any sort of restrictions as to what the Court of Justice was allowed to consider might amount to such conditions. It simply asked the question, what are the conditions? And the question didn't ask in terms what knowledge was required by the phrase being aware of such use, but that was because it asked a more general question of what the conditions were. Now, my friend devoted some time in his written submissions, and again this morning, to the Advocate General's opinion. I think my Lord Justice Nugee, if I'm expected to say so, put his finger on it by identifying paragraph 74 of the Advocate General's opinion. Because that paragraph 74 on page 86, that shows the Advocate General thought it rather clear from the wording. But my submission, it is clear for the wording for all the reasons I've just submitted to the court. And the point here is that the Advocate General has said it's 3 conditions rather than 4. But that's only because she hasn't mentioned bad faith as a separate. Otherwise, it's the same as the Court of Justice. And the Advocate General's opinion is very clear. It gets repeated a little bit later on. The relevant knowledge must be of both registration and use. And it's my learned friend who's submitting that it's quite a long and detailed consideration generally by the Advocate General. But in his submission, the Advocate General has done just as bad a job as the court itself of answering the question, because they haven't considered the particular wording that he says should have been considered. But that's just not the way the Court of Justice works. The Court of Justice works, particularly for matters of European law, as this was, in precisely this way. It's not open to outsiders to criticise the way it works. And coming to the Court of Justice's own answer, that's at the same same tab. I'm not going to read it out because I'm sure my lords have read it plenty of times. It runs from paras 51 to 59, and then it's repeated at 62 and also repeated at the end at 85.1.
Can I take you back just a moment? You said this is how the Court of Justice works. It works in precisely this way.
Yes.
I haven't quite understood what this way is. What is it?
Oh, perhaps I'm using too much shorthand. Sets out the question, looks at the policy, gives the answer. Doesn't approach it like an English court might.
But it's not tied to the particular facts because it's a preliminary issue of law.
Correct. I'm probably a little bit too brief, but the point I was trying to make was they set out the question, which are shown my lord, and then the analysis from paras 51 to 59 is they might not go into the same level of detail as an English court would, but what they have done is, just looking at it, para 51 is they reminded themselves what the question is, and then para 52 they've reminded themselves what the policy is, because they've gone to that exact recital that I took the court to. And then paragraph 53, they've said it's apparent from the wording, which is what the Advocate General has said. So an English court might have said more, but the Court of Justice didn't. The Court of Justice thought that it's apparent from the wording, that's all we need to say about it. Okay. And my submission, it is apparent from the wording for all the reasons already given. And then they set out the answers to the question in paras 54 to 59. And para 58, it's not subject to significantly less reasoning than 56 and 57 for that matter. And yet no one's criticising those. He said a little bit more about 54, in para 54 about the later registered trademark, because as pointed out, because it refers to later registered trademark, registration of that mark in a member state concerned constitutes a necessary condition. The period of limitation and consequently acquiescence cannot therefore start to run and so forth. And the only point in 55 is pointing out that member states are free to determine the effects. Well, they're free to determine various things, but third line down, member states remain free to fix the proceedings of procedure concerning the registration, revocation, and validity, and so forth. But none of that makes any difference to the conclusion that it's talking about a registered trademark once you get there. In my submission, there's no reason to suppose that paragraph 58 has some different status in law to paragraphs 54 to 57. Now, my learned friend criticises the text, in particular paragraph 58, as lacking certainty. I've said a little bit about that already, I'll say a bit more now. My learned friend draws a sharp distinction between proving knowledge of use and proving knowledge of registration. He doesn't suggest there's anything at all uncertain about proving the entire earlier proprietor's knowledge of use of the later mark. But just pausing there, suppose the relevant market is a large and diffuse one, perhaps split along distinct lines in terms of geography, customers, trade channels. In practice, it might be quite difficult to know if a particular use is one you should be worried about if it's happening in a different part of the country or to different customers and so forth. And that's a problem for national marks, but it's even worse when one's considering European marks, because you might not know what's happening in southern Italy, to name but one. But Malone and Friend regards such a test as presenting no problems at all in terms of legal certainty. But as he puts it in his paragraph 31A, quote, "It will often be impossible to find out or prove anything about the earlier proprietor's knowledge of the register." And his submission, proving this knowledge, presents often insurmountable problems in terms of legal certainty. And I don't accept that for a moment. Knowledge is a fact like any other to be proved by way of evidence. It was proved by evidence in this case. The judge made findings of fact about it. And proving knowledge of the contents of a publicly accessible register would, if anything, be expected to be easier in terms of certainty than proving knowledge of a different part of the market. And that's particularly so in continental legal systems, which have
How do you do that in circumstances where all the relevant documents are privileged?
Well, I think the answer to that is you have a trial about it. Malone and Friend did have a trial about it. And he drew the court's attention to these matters below.
Yes, but the court can't draw any inference from the claim to privilege. The law is clear on that. So, one, all the documents are privileged. Two, the court can't draw any inference from the claim to privilege. So there's an evidential vacuum.
But that's a familiar problem. One gets it in relation to patent amendment, for instance. And the usual solution is, it may be you've not proved your case.
But the burden is on the parties asserting knowledge. There can't be any burden to assert absence of knowledge, or are you accepting that that is how the burden lies?
No, the burden lies as set out in the statute. Well, the fact might be procedural evidential difficulties. In my submission, I take that head on. It's got nothing to do with how the statute should be construed. I think Malone is putting a situation whereby the UK law of privilege and the UK law of privilege applying to trademark agents somehow affects the proper interpretation of Article 9 of the European Trademark Directive. I don't see why that's a proper approach at all. I don't accept that procedural or evidential difficulties in one member state are relevant. And in this case, as I said earlier, it would have been so easy for Malone and Friend to prove that knowledge if his clients had informed the public the mark was registered. And they could have done it so easily by choosing to apply the Arnold logo or choosing to make a statement on their goods. But they chose not to do that. Now, Malone and Friend hasn't told this court why not. The reasons don't matter.
Because most trademark proprietors don't. I mean, if you look around you, yes, you see it from time to time, but an awful lot of the time, most trademark proprietors don't use the RC.
Well, sometimes they do, sometimes they don't. I'm responding to the submission that Malone and Friend says it would be so enormously difficult to prove knowledge.
Yes, but you're suggesting that we should draw some inference from the absence of an explanation. Well, that's what I'm jibbing at.
Yes, well, I'm not going that far. I'm not saying you should draw an absence from the failure of an explanation. I'm saying that in terms of legal certainty, it would have been easy to get round that. They could have proved our evidence of knowledge use by simply telling us. In fact, that's what they did do eventually in correspondence. Eventually, they did say the BVI company has got these trademarks. The UK company, to whom the letter before action was written, didn't have any relevant trademarks at all. That's D3 and D4. But in any event, why does any of this matter? I don't accept the proposition that one should construe the statute by reference to what dishonest or unscrupulous people might do, which I think was part of Malone and Friend's submission. He says, oh, you might choose not to, you might deliberately not look at the register, and so forth. The law has tools to deal with such persons, as my Lord Justice Arnold observed in Coombe. You can't turn a blind eye.
Was that left open in Budvar as to whether knowledge could be what I think the Advocate General called potential knowledge?
Yes, they didn't find it necessary to resolve that because the way the Advocate General's opinion worked was it started off saying, well, it's clear that they've got to know of it, registration and use. And then she went into, is it potential or actual, concluding it's not necessary to reach a conclusion on that. And the Court of Justice seems to have agreed it wasn't necessary to reach a conclusion because they didn't reach a conclusion on that.
And is that something left to each member state, or is it a matter of EU law, or don't you know?
What we do know is must be aware of the registration of the letter trademark and use of that trademark. On its wording, it doesn't seem to leave much room for anything other than what it says, must be aware of. But whatever the test is, and the judge's finding, we satisfy it. Now, if my lords and my lady are with me, the court is bound by Budvar. The next question is whether the court should depart from it. And I've said the answer is no. I'll look at the authorities my learned friend has cited as to which he says support such a departure, because it's my submission they do no such thing. Now, the first of them is high-tech, and I think my learned friend's position may have modified slightly. In his skeleton argument, he suggested that in high-tech the CGAU somehow overruled the fourth prerequisite from Budvar.
Well, they plainly didn't do that.
Yeah. It certainly didn't do so secretly. But the simple answer to high-tech, the judge gave that answer in judgment paragraph 36. It was concerned with how a period of acquiescence can be brought to an end. And in particular, whether this can be achieved by sending a letter before action without more. So it was what stopped time running, not what started. And therefore, once one gets to the point that they're dealing with a different case entirely, there's not very much one gets out of high-tech, other than that they cite Budvar as good law. And I would show the court that. High-tech Court of Justice decision is at A11 tab 7. Now the questions which we referred, the court has taken from yesterday, questions 1 and 2 tab 44, don't need to look at that. We do see that Budvar is cited good law when it's considering the questions, and that's, I'm going to pick it up at para 45, or rather para 46. On page 244 of the bundle, A1.1 tab 7. And all I'm doing here is showing that high-tech was cited by the Court of Justice as being good law. Now, admittedly, not the paragraphs we're worried about, but there's no suggestion they thought there was anything wrong with it. And it's cited at paras 46 and 49 and also 52. Now, in my submission, if they were actually overruling Budvar or criticising it in some way, they wouldn't be citing it. But in any event, they're treating it as good law. And there was a point on the Advocate General's opinion in the same case as well. It's the source of a phrase that I've used already in my submissions to my lady and my lords about how Budvar is the foundation. And one gets that from paragraph 1 of High-Tech Advocate General Fitchett Seller's opinion, tab 6, that's the previous tag, page 220. And it's towards the end of paragraph 1, nearly 16 years later, than 2006, and after the Court of Justice had laid the foundations of the community regime for the limitation and consequence of acquiescence.
Well, all she means by that, sorry, he means by that, I think, is it was the first decision, because it was.
Well, that's certainly true. If foundations just means it was the first one, then yes. But it continues to be the binding law of the Court of Justice. I'll demonstrate by looking at the other decision. And certainly, if there was an opportunity to define the scope of that legal regime, it wasn't taken to say that Budvar was in any way wrong. Now, so far as Coombe is concerned, I'm not sure we have to spend too much time on that. because, as my Lord Justice Arnold said yesterday, nobody in Coombe suggested departing from Budvar. Now, the point there is simply that, well, it emphasises the lack of any UK criticism of Budvar. In other cases, where the court is invited to depart, applying the Supreme Court's test, there's some criticism somewhere of Budvar. I don't think my learned friend took you to any criticism anywhere. He just took you to some decisions which he said were inconsistent with it. But nobody's ever said that Budvar is wrong. There's no academic articles about that. And that was as true in Coombe as it was anywhere else. Now, my learned friend did say there was a point on the policy of Coombe, but in my submission one doesn't get anything from that either, because well, let's pick it up at A1.2 tab 9. I think there was a suggestion that there was some sort of policy change, or at least a policy recognised here. But, sorry, I haven't given the reference, paragraph 39. It's Lord Justice Arnold's judgment. And paragraph 39 is the reference to Budvar, the 4 prerequisites. And paragraph 41 over the page, no dispute that the reasoning is equally is equally applicable to the directive. Retained union law, neither side suggested we should depart from that. My learned friend also relied on paras 65 to 67 and paragraphs 65 to 67, found on page 329. And it's what my Lord Justice Arnold said about the broader purpose of the legislation as explained by the CJEU. But my Lord's divided it as to 3 interrelated aspects. But my Lord's not adding anything over and above what the Court of Justice said in Budvar. In para 66, my Lord does refer to earlier UK cases and makes the point that trademark cases get worse with neglect. That's true, but that's not changing the policy of the European Directive at all. That's just a statement of what we observe in UK practice. And then the third aspect in para 67 was the need for legal certainty. And that was important in Coombe because that was a case where the acquiescence defence was actually run. But in my submission, there's no difference, no enlargement by my Lord Justice Arnold in these paragraphs of his judgment over the 2 purposes set out in the recital of the directive and the consideration of the Court of Justice. There's just no change. And that's not surprising, because it was about a different point. If my Lord Justice Arnold had felt that Budvar was lacking in legal certainty for some reason, then para 67 might have been a place to mention it. But of course, that wasn't an issue in that case. So the short answer is that Coombe is just dealing with something else. It just doesn't help my learned friend at all. My learned friend in his skeleton actually put it as far as the Court of Justice had somehow departed, his word, from Budvar and High-Tech. And as I said earlier, it somehow departed in a way which got rid of the 4th prerequisite, but apparently only. So my submission, that's all one gets out of Coombe. No, that's not right. It doesn't support my learned friend on the policy at all. Now that brings us to Ghibli, much pressed by my learned friend. Now the Ghibli case wasn't cited at all below, but we've got it now. And it's a decision of the EU IPO Board of Appeal, as it's now known, predating Budvar. Now, as my Lord Justice Arnold will certainly know, but other members of the court may not know, the EUIP used to be known as OHIM, OHIM, and it's the European equivalent of the UK Intellectual Property Office. And like in some ways, yes.
It doesn't deal with patents, for example,
Yes.
unlike the UK IPO.
Yes, it was intended to be a summary. The problem with any summary is they're not quite right. Well, anyway, I'll press on. The point I was actually making was this one. It's specialist. I accept that in the sense that they apply specialist law. But the EU IPO is not a judicial or lawmaking body. It's not like the Commission or the General Court or the Court of Justice or Council of Ministers or any of these things. Now, I submit that this case is A, wrong, and B, not binding. I'll deal first with why I say it's wrong. Now, I've set this out in my skeleton at War Bundle, tab 5, page 73 for reference, but I'll make submissions on the basis of Ghibli.
Which paragraph number's in your skeleton?
I was just giving the reference
sorry.
to my skeleton. I think it's paragraph 20, but having done that, I'm now going to take the court to the actual authority. Sorry about that. Can I invite the court, therefore, to go to A1.1 tab 1, and that's Ghibli itself, which, oddly enough, turns out to be another case of cleaning machines. Who would have thought that cleaning machines was a rich source of trademark and trademark law and acquiescence as well. The key paragraphs here are, start with paragraph 1, which just tells us what we're worried about. Ghibli was the CTM proprietor, and it's proprietor of that mark there, which we see in paragraph 1, registered on 25th of June 2001. So that was the mark actually applied for, the one that Ghibli SPA, the proprietor, was trying to register. And paragraph 4 is an earlier mark belonging to the cancellation applicants, which was an earlier Italian trademark registration, which is set out there. And it was earlier because it dated from 1st September 1979. So again, one can see, well, that's pretty similar. But actually, there were somewhat unusual facts in this case. Now, one can see the unusual facts of it on page 6 of the report, which is paragraph 13. Now, this is just the submissions and arguments of the parties thus far. So this is the cancellation applicants wanting to stop this mark being registered. And this refers to the fact, a few lines down, the contested decision erroneously recorded the knowledge of the CTM proprietor's Italian mark registration filed in 1976, which is not denied, as being knowledge of the contested CTM filed in 2000. Now, what might be slightly confusing is this report doesn't show that earlier Italian registration. The one on page 1 was actually a different one. It was filed in 75, not 76, but it belonged to a different person anyway. So we're not actually shown the CTM proprietor's earlier Italian registration. But we see that the cancellation applicant's knowledge of that earlier Italian registration was, quote, not denied. So that clearly wasn't an issue. Now, that's the somewhat unusual fact. So let's pick it up at paragraph 35, where it begins to discuss the earlier Italian trademark registration. And what they do in paragraph 37 is the Board of Appeal does set out Article 53.2 CTMR. We don't need to go to it. Leonard Friend did that yesterday. But they have set it out. This is Article 53.2. So it refers, for instance, 4 lines down, in the use of a later community trademark. So I made all these submissions in relation to Section 48 of the UK Act about the registered mark. The word here is later community trademark. We'll come back to that. In which the earlier trademark or other earlier signs protected while being aware of such use. If my lord and my lady want to make a manuscript note here, A2.1/26, page 149 actually is the article in question, but it's correctly set out here. Now, the reference to a later community trademark is important because, as we'll see in a moment, Article 6 of the Community Trademark Regulation states that a community trademark shall be obtained by registration. So if you talk about a community trademark, it's something that has been obtained by registration. And prior to that, it was only an application, not an actual registration. Now, coming back to Ghibli here, they've set it out correctly in 37, and then paragraph 38 again refers to the cancellation applicant's argument that although he knew of and tolerated the proprietor's earlier trademark registration, which we've not seen, for a similar mark, he didn't know it was registered as a community trademark. And we can see that the Board of Appeal clearly didn't think much of that argument, because in paragraph 40 they say, however, the fact remains that an essentially identical, slightly figurative version of that sign has been granted, again talking about the CTM proprietors Italian trademark registration, has been granted community trademark protection, etc., and so forth. Now, with respect to the Board of Appeal, none of this should have played any part in the Board of Appeal's legal reasoning, because all it should have been asking itself was whether there was a legal requirement to know of the CTM registration. But it's gone into the facts, and it's started to talk about how similar the trademark registration applied for might be to some other registration. That's the point they're saying in 40. Now, that's a matter of fact. That had nothing to do with the point of law. And then, having given indication they don't think much of this factual argument, they do go on to the objective of Article 53 to CTMR at paragraph 42. Now, it's not clear from the report, at least not as far as I can see, what materials or arguments the board took into account when they formulated what they considered the objective of Article 53.2 was. Did they approach it in the same way as the Advocate General and the Court of Justice, or some other way? But in any event, what they've done is they've actually rewritten it, and they cited it correctly on the previous page, but they've rewritten it into a new form of words, which they themselves emphasise, by use of italics, about, quotes, the long-term presence of the conflicting later sign on the market, close quotes. Now, these words are nowhere to be found in Article 53.2 itself, and the two errors here are, during the rewriting process, they've omitted the express reference in Article 53.2 to a later community trademark, which by virtue of Article 6 means a mark which has been obtained by registration. And it's also omitted the express reference to no longer being entitled to apply for a declaration that later trademark is invalid. As I said earlier, that in my submission implies both that the later mark is registered and the early proprietor knows it's registered. So that is, having rewritten Article 53.2 in those two respects, it's not surprising the board then goes wrong in my submission. Now, Article 45 is when they move on to the Article 6 point that I already mentioned. It must be noted that pursuant to Article 6 CTMR, a community trademark is obtained by registration. This means the right of the CTM proprietor to come to legal existence the effective date of the registration of the community trademark, not on a later date in which the registration of the CTM will be published. Now that, of course, is contrary to my learned friend's second ground of appeal, but just focusing on what they say here, they have woken up to the significance of Article 6. But my submission, they failed to realise the importance it had to the preceding paragraphs of their judgment, because 53.2 talks about a community trademark in town. And as they say in paragraph 46, moving on, they make the same point about the importance of registration all throughout 46. but about 2/3 of the way down, they say as a CTM comes into existence with its registration, again Article 6 CTMR, for the purpose of Article 53(2) CTMR, the use of the sign as a trademark cannot technically commence before the date of registration, leading to the conclusion set out in the last sentence. Hence, will the period of 5 successive years stipulated in Article 53(2) CTMR rates the cancellation applicant's awareness and tolerance of the use of contested sign. The calculation of the 5-year period cannot start earlier than the date of the registration of the CTM, taking also into account a CTM neither exists nor can therefore be invalidated before being registered. So they're doubling down on rejecting Millennium Friends' second ground of appeal here. But whereas those bits doing down the second ground, I respectfully criticise the decision because it's just not right in terms of its analysis of Article 53(2) as set out in paragraph 42. Now, the next point is that this decision isn't binding anyway.
Well, it's not suggested it is.
Yes, and I've perhaps pushed too hard at that open door by saying it's not binding. I've set out a number of reasons as to why not. Not being a judicial and law-making body is the first one. I would show the court just a few things about the provision for the office, and if the court could please take A2.1. The CTMR makes detailed provision for the office, and it's well, the note here actually is actually a later version of it, but the point is exactly the same one. The Board of Appeal members are not all legally qualified. Only at least 2 of them, and that is Bundle A2.1, tab 27, page 264. Article 135. 1351 says the Board of Appeal should be responsible for deciding on appeals from decisions, and these are all internal organ decisions, so internal EU IPO decisions. And then 2, decisions of the Board of Appeal should be taken by 3 members, at least 2 of whom are legally qualified. But the implication is that not necessarily all of them. And then I don't think we need to go to this. I'll just give the court the reference. My learned friend can check whether I'm right about that. The appeals from Board of Appeal to the General Court, which used to be known as the Court of First Instance, and then General Court appeals are subject to the right to appeal, further appeal to the Court of Justice of the EU on points of law. And the best place to find that is actually Curly A2.2/31, page 416, paragraph 8095. I don't propose to take the court to it because I don't think that's disputed. But the point is that it goes on appeals to the General Court and then the Court of Justice. Now, I set out a number of cases in my skeleton argument, probably too many of them, all saying different versions of the same thing, that it's neither a court nor a tribunal. I'll go to Kruger for that one, just to show the status of it. It's pretty succinct. That's A1.2. F16. Page 501, paragraphs 62 at the top. And the point is simply proceedings before the boards are administrative and not judicial in nature. A number of authorities making the same point, which I've cited. Now, my learned friends also relied on the fact that Ghibli has made it into the EU IPO guidelines. He did take the court too, but I think he skipped over a couple of words I'd like to read out. And the guidelines are at A1.1 tab 2, page 18.2. And the reason we're looking at this is my learned friends places quite heavy emphasis in the case that Ghibli's made it into the EU IPO's own guidelines. And my answer to that is that's not even binding on the EU IPO itself. And one gets that from, if my lady and my lords are on page 18.2, 5 paragraphs down, therefore the office's guidelines are not legal acts, but self-imposed rules of conduct adopted by an administrative decision. It's hardly the highest of praise in the EU IPO itself. My other friend did go to the substance of these non-binding guidelines, but they're rather odd. And they're rather odd because they seem to overlook the binding law of the Court of Justice. If my lady and my lords could go to page 24 in this tab. This is the section dealing with acquiescence. And they've said the burden of proof is on the proprietor of the contested EUTM to show that. And then they set out 3 conditions. And they actually cite Budweiser, and that's the Budweiser case, C48209, paragraph 44. But they say all 3 conditions must be fulfilled. But there aren't just 3 conditions, there are 4. If they'd read Budweiser, they would have seen there were 4. And they have cited Budweiser. They obviously got as far as paragraph 44 of it, anyway. And then over the page, the EU IPO seem to dig themselves deeper in by referring at the top of the page, proprietor of the contested mark cannot be required to approve, in addition to invalidity applicant's awareness of the use of the contested ETM, the invalidity applicant's also aware of its registration. And they've cited their own case for that, Ghibli. And with respect to the Board of Appeal, taking this approach on its own guidelines and simply ignoring the Court of Justice and Budvar isn't something that is properly open to them to do.
No. The guidelines aren't promulgated by the Boards of Appeal. The guidelines are probably promulgated by, I forget what the division is now called, but it's a completely different division of the EU IPO.
Well, in that case, another reason why my learned friend's not entitled to place very much reliance on.
No, because it's a statement of the office's practice, and it's followed daily by the examiners and the members of the examining division and of the opposition and cancellation divisions, and also the members of the Boards of Appeal use it as a reference as well.
Yes. In that case, I revise my submission. It is an incorrect statement of the law. They may be following it daily. Yeah, there are 4 conditions, not 3. Budvar says there's 4. And Ghibli is contrary to Budvar. Now, the next case on which my learned friend relied was Turk Hava Yolari, and that was one that he mentioned for the first time as supplemental skeleton Friday before last. Now, no reason given as to why that wasn't mentioned earlier, but Millennium Junior Miss Messenger tells me that it isn't listed in any of the search functions, such as Darts IP or Westlaw, is actually dealing with acquiescence.
I'm sorry, I didn't hear that. Could you say that
yes,
again?
Yes, Turk Hava isn't listed in any of the search functions in Darts IP and Westlaw.
So Mr. Seville could be forgiven for not finding it any earlier?
Yes, but that's because it's not a case about acquiescence in my submission. There's a passing reference to acquiescence in the middle of it. Right. But it is in fact, let's go to it. Go to A3, tab 38. Now, let's be clear, the reason I'm saying is that, as I say, this was a case about something else entirely. It's not indicating any dissatisfaction with Budvar, it's really about a different point. The point it was actually about, one can see from, I can see from head notes 1, 2 and 3, it was really just a likelihood of confusion case. And if you look at the key words on the top, none of them are about acquiescence either. And that's clear. If one reads the whole thing as a whole, you can see that it is actually essentially dealing with relative grounds for refusal. And there's only a passing reference to acquiescence at all. One gets another clue to that from the cases referred to on page 152 to 153. Bodvar is not even mentioned here, so the General Court doesn't seem to be referred to Bodvar, because presumably each 31 cases referred to would have mentioned Bodvar if it had been referred to by anyone.
Yeah, but that's a list of cases that are referred to in the decision. They don't report citations in the ETMR because they don't know, because they're not publicly accessible.
Right, well, I wasn't aware of that, but I accept that point. But the point remains that there's, it's really about a different point entirely. If one looks at judgment paragraph 17, one can see what the actual argument was all about. Now, it's not...
Sorry, paragraph?
Paragraph 17, page 155. Which is infringement of Article 61A of the regulation, read in conjunction with Article 81B, and infringement of the obligation to state reasons. And then they deal with the obligation to state reasons, and there's nothing in paragraph 19 to 25. And then paragraph 26, the beginning of the first plea in law. And we're seeing at paragraph 26, it's all talking about likelihood of confusion, and it goes on through quite a large number of paragraphs to consider likelihood of confusion. For instance, paragraph 32, page 157, paragraph 33 set out broad assessment of likelihood of confusion, and on, and so on and so forth. The first reference to acquiescence at all comes at paragraph 48. And then at paragraph 49, it says it follows that 4 conditions must be satisfied before the period of limitation, and they set it out. But again, they don't refer to Bodvar, and yet this was the place where they should have been referred to Bodvar, because that was the Court of Justice authority as to what the conditions were to be satisfied before the period of limitation starts.
Yeah, but as I observed to Mr. Saintville yesterday, we get into the problem that when you read General Court decisions, and this happens time and again in all areas of trademark law, they constantly cite their own previous decisions and relatively rarely cite Court of Justice case law, even if the Court of Justice case law is bang on point.
Yes.
So the fact that they don't refer to Bodvar is not necessarily attributable to any lack of awareness of it. It is more likely attributable to their ingrained habit of citing their own case law.
That may well be right, and I'll gratefully embrace it. But then it's hardly a reason to answer the Supreme Court test and learn a friend's favour if the General Court decisions just have a practice of referring to their own decisions. He was trying to get out of this. There's some sort of dissatisfaction or confusion in Europe.
No, the point he was making was a different one, which is that objectively one can see that the Court of Justice and the EU IPO are applying a different test. And so his submission was, in those circumstances, if we were still an EU member state, we would be bound to refer. We can't refer, therefore we have to decide. Your answer is very straightforward, namely Bodvar's retained EU law, it's binding, and this is not a sufficient reason to depart. But the divergence in the case law is one of the reasons that he relies upon for saying that we ought to do so. It's as simple as that.
Yes, I follow that. I'll just make one more point, and then I think that's probably... Is that clock accurate?
No,
No.
it's 101.
Shall I stop there then?
Have you finished with this case?
I finished with this case, yes. I was going to look at Basile next.
Yes.
Well, actually, the only point I was going to make before we close this one is that what they refer to in the second line on page 161 is the General Court's decision in
Yes.
Basile, not the Court of Justice, because the Court of Justice corrects them later. I'm sure.
Yes, indeed.
Yes.
Absolutely.
Yes.
Oh, in that case, I've probably done my point then. Right, I'm very good.
How are we doing?
How are we doing? I was going to talk about, well, I think the short answer is, I would say another hour.
And then we've got reply, then issues 4 and 5.
Yes.
Presumably they have to be much shorter because we still have to finish at 4:30.
Yes.
Thank you very much.
Court line
2 o'clock,
is
please.
April.